on protecting the right to vote. I'd like to welcome our panelists. First, Professor Mark Rohr, Professor of Law Emeritus of Shepherd Robb College of Law, Nova Southeastern University. He will be a panelist. Next is Executive Director of Florida ACLU, Howard Simon. And next is Broward County Supervisor of Elections, Dr. Brenda Snipes. And next is President of the Florida Rights Restoration Coalition, Desmond Meade. And last but not least is Professor Charles Zeldin, PhD, Department of History and Political Science, NSU.
How are we doing on sound? Okay? Yep. All right, welcome, ladies and gentlemen. Okay. I have taught constitutional law for many years at the law school at Nova Southeastern University. And when I was asked to moderate this panel today, I thought y'all might benefit from hearing a little bit about the federal constitutional law regarding voting rights. Hopefully it won't be too mesmerizing, but do pay close attention, there will be a quiz. Now, I begin by raising the question, what does the United States Constitution say and not say about the right to vote? You might be surprised about this. The original Constitution, as ratified in the late 18th century, does not at all explicitly reference a right to vote. In Article 1 of the Constitution, of course, the founders created our Congress, Senate, and House of Representatives. But here's what those provisions said with regard to who gets to vote for members of Congress. Article 1, Section 2 says that those who elect members of the House of Representatives, quote, shall have the qualifications requisite for electors of the most numerous branch of the state legislature. So it really means that you had to look to state law to see who got to vote for members of Congress. What about the Senate? Well, even more restrictive. Article 1, Section 3 of the original Constitution says that the Senate of the United States shall be composed of 2 senators from each state, chosen by the legislature thereof. Now that was fixed, if you will, by the adoption of the 17th Amendment in 1913, which now says that senators shall be elected by the people of each state. But the provision there is the same as with regard to the House of Representatives. The senators will now be elected by the people, but which people? Well, those who have the qualifications requisite for voting for the most numerous branch of the state legislature. What about electing the President of the United States? Well, you know that the founders gave us the Electoral College, and in Article 2, Section 1, which established the Electoral College for selecting the President, it says that each state shall appoint in such manner as the legislature thereof may direct the electors from that state. So if you go to the year 1914, after we had the ratification of the 17th Amendment, the United States Constitution really didn't specifically say that anybody gets to vote. But you really had to look to state law to see who got to vote. And of course we know, especially as we go back further and further in time, that it was never everybody. Those are the only references to voting, really, in the original Constitution. But of course we had some amendments along the way that made important contributions with regard to the right to vote. But those amendments generally simply removed obstacles to voting. I don't mean to denigrate the importance of those amendments, but rather than create a right to vote per se, they removed discriminatory obstacles to the right to vote. And so, the 15th Amendment, and here I want to look to the precise language of the Constitution with regard to these amendments. The 15th Amendment, adopted, I should say ratified in 1870 after the Civil War, says, the right of citizens of the United States to vote shall not be denied or abridged by the United States or any state on account of race. And the amendment also authorizes Congress to enforce this article by appropriate legislation. Then, of course, we had the 19th Amendment, ratified in 1920, which says, the right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of sex. Far less momentously, we have the 26th Amendment, ratified in 1971, which says the right of citizens of the United States who are 18 years of age or older to vote shall not be denied or abridged by the United States or by any state on account of age. Now, it's natural for us to think of these amendments as giving people the right to vote. The 15th Amendment gave African Americans the right to vote. But of course, that was only true if they could otherwise vote according to the law of their state. And of course, at that time, 1870, we weren't talking about African American women, only men. We think of the 19th Amendment as giving women the right to vote. By that time, that was essentially correct. But again, the U.S. Constitution never says anything specific about giving anybody the right to vote, but these amendments have the very important effect of removing discriminatory obstacles there too. Another amendment deserves mention. I think it's fair to say that it's a unique amendment. It's the 24th Amendment, ratified in 1964, which says that the right of citizens of the United States to vote in any election for president, Senate, House of Representatives, shall not be denied or abridged by failure to pay any poll tax, P-O-L-L, poll tax. So a constitutional amendment to ban the use of a poll tax as a condition for voting in federal elections. What about the states? I'm not sure why the amendment as written was limited to voting for federal officials, but 2 years later in 1966, in the Harper case, the U.S. Supreme Court struck down as unconstitutional the use of a poll tax in state elections, finding that this was a senseless and unconstitutional abridgment of the right to vote. There's one other constitutional provision that must be mentioned with regard to the right to vote. The most unusual provision is Section 2 of the 14th Amendment. And it's sufficiently lengthy and boring that I'm not going to risk losing my audience by reading it to you. But it's mostly of historical interest. Again, the 14th Amendment having been ratified after the Civil War, but it's got one feature that has lasting significance. Namely, the very strong implication in this provision that it's permissible for states to deny people the right to vote if they've been convicted of a crime. And the United States Supreme Court interpreted it exactly that way in a 1974 decision called Richardson versus Ramirez, which upheld the power of a state to deny the vote to persons who have been convicted of a felony. You're going to hear more about that precise issue later today, but now you know the U.S. Constitution, unless the Supreme Court changes its mind someday, doesn't give convicted felons a constitutional argument that they should be entitled to vote. A very peculiar provision in the United States Constitution. Well, folks, despite the fact that the Constitution does not explicitly refer to a right to vote, the U.S. Supreme Court has, for most of its recent history, been very protective of the right to vote. And that approach by the U.S. Supreme Court is reflected in this language that I want to read to you, passages from a 1964 Supreme Court opinion called Reynolds v. Sims, Chief Justice Earl Warren speaking for the court. And as you hear what I'm about to share with you, you may find it a little jarring. You may think some of what you're hearing is inconsistent with what I've already told you. Well, maybe it is, but here it is. the U.S. Supreme Court, speaking through Chief Justice Earl Warren in 1964, as a way of showing you how the Supreme Court came to feel about the right to vote. Here it is. Undeniably, the Constitution of the United States protects the right of all qualified citizens to vote, in state as well as in federal elections. A consistent line of decisions by this court in cases involving attempts to deny or restrict the right of suffrage has made this indelibly clear. It has been repeatedly recognized that all qualified voters have a constitutionally protected right to vote. Undoubtedly, the right of suffrage is a fundamental matter in a free and democratic society, especially since the right to exercise the franchise in a free and unimpaired manner is preservative of other basic civil and political rights. Any alleged infringement of the right to citizens to vote must be carefully and meticulously scrutinized. Now, he's speaking in the context of one of the early and important cases invoking the one-person, one-vote principle. And the Supreme Court has given its solicitude to the right to vote primarily, I would say, in cases involving some sort of discrimination involving the right to vote. Not typically racial discrimination, but other forms of discrimination that impaired somebody's right to vote, and more often than not, the Supreme Court found such discrimination to be violative of the Equal Protection Clause of the 14th Amendment. Now, I think it's important to share this aspect of constitutional law with you. What I'm going to tell you is true beyond the area of voting rights. But if you wanted to argue that a particular state law or practice is unconstitutional under the 14th or 15th Amendment because it is racially discriminatory, it will not suffice to show that the law or practice has a disproportionate negative impact upon African Americans, for example. Disproportionate impact is not enough. Rather, the challenger, the one trying to establish that we have invidious racial discrimination, would have to show discriminatory purpose motivating the enactment of the law or the adoption of the practice. Unless, of course, the law was racially discriminatory on its face, but we don't see much of that anymore. So this is a well-established principle going back at least 4 decades at the Supreme Court. You can't make it a racial discrimination case as a matter of constitutional law just because of disparate impact on racial minorities. Keep that in mind. Now, one particular case that I want to mention to you that stands by itself, but it's going to be relevant to what I think we're going to hear from some of the panelists later on, not a racial discrimination case, involved photo ID requirements for voting. And I wanted to share with you the fact that in 2008, the United States Supreme Court, in a case coming out of Indiana, upheld the validity of a photo ID requirement for voting. There was no majority opinion. Perhaps to your surprise, Justice Stevens wrote the lead opinion in the case, rejecting the challenge to the photo ID requirement for voting. I think the essence of the majority's point of view, no majority opinion, but of course the majority, was that the evidence presented at trial did not establish to the court's satisfaction that the burdens imposed by a photo ID requirement outweighed the state's legitimate concern about voter fraud. Finally, but don't get too excited because this takes a while. Finally, let me introduce to you in a relatively quick and oversimplified way the Federal Voting Rights Act of 1965. And this is going to come back to the Supreme Court, which is why it's on my agenda here. The Voting Rights Act of 1965 was originally supposed to be a temporary measure, but it's been reauthorized by Congress a handful of times, always with some changes, most recently in 2006. What this act does basically is this. Section 2 of the act forbids any, and I'm partially quoting here, but I'm not going to keep saying quote unquote. Section 2 forbids any standard practice or procedure that results in a denial or abridgment of the right of any citizen of the United States to vote on account of race or color. And the federal government and private individuals are authorized to bring suit to enforce this provision, which applies on a nationwide basis. Other sections of the Voting Rights Act targeted only some parts of the country. Initially, these so-called covered jurisdictions were those states or counties that had maintained a test or device, quote unquote, like a literacy or a knowledge test, as a prerequisite for voting as of November 1st, 1964, and had less than a 50% voter registration or turnout in the 1964 presidential election. This was the so-called coverage formula. Remember that phrase, which was last modified in 1975. In those jurisdictions, which ultimately accounted for a number of states and a number of counties, in those jurisdictions, Section 4 of the Act banned all such tests or devices. Section 5 created for those jurisdictions the so-called pre-clearance obligation, meaning that in those jurisdictions, no change in voting procedures could go into effect until approved by the Attorney General of the United States or a three-judge court in Washington, D.C. A jurisdiction could obtain such pre-clearance only by proving that the proposed change had neither the purpose or effect of denying or abridging the right to vote on account of race or color. Now, aside from this extraordinary pre-clearance concept, I want you to notice two striking aspects of the Voting Rights Act, which are related. First, it made some practices illegal because they had the effect of impairing the right to vote on the basis of race without any need to prove discriminatory intent. You see? So that a challenge brought under the statute is more likely to succeed than a challenge brought under the 15th Amendment itself. Secondly, and related to the first point, Congress prohibited some practices, most notably literacy tests for voting, that were not themselves unconstitutional. Why do I say that? Because the Supreme Court in 1959 had ruled that a literacy test for voting was not unconstitutional. So, see, Congress in the Voting Rights Act made some practices illegal that were not themselves unconstitutional. How did Congress get to do this? Well, I trust you know that the federal government is, in theory, a government of limited powers, and Congress has to have some basis in the Constitution for everything it does. How then was Congress able to enact the Voting Rights Act? The answer is, pursuant to its power set forth in the 15th Amendment, to enact legislation to enforce the purposes of the 15th Amendment. Well, suits were brought challenging the constitutionality of various provisions of the Voting Rights Act, starting as early as the late 1960s. But all those early challenges were rejected by the Supreme Court, a majority of whose members were deferential to Congress in this context, and who were fully aware that they were upholding the power of Congress in the name of enforcing the 15th Amendment to impose prohibitions that were clearly not imposed by the 15th Amendment itself. Get it? But now it's June of 2013. And then the Supreme Court handed down its 5-4 decision, yeah, that 5-4, in the case of Shelby County, Alabama versus Holder, in which the court declared that the Act's coverage formula unconstitutional, exceeding Congress's power to enforce the 15th Amendment. Chief Justice Roberts, for the majority, reminded us that, quote, there is a fundamental principle of equal sovereignty among the states. Accordingly, the statute's current burdens must be justified by current needs, and any disparate geographic coverage must be sufficiently related to the problem that it targets. The coverage formula met that test in 1965, he said, but no longer does so. Congress, if it is to divide the states, must identify those jurisdictions to be singled out on a basis that makes sense in light of current conditions. It cannot simply rely on the past. So the problem, in essence, in the majority's view, was the fact that these covered jurisdictions, the ones that had to abide by the pre-clearance obligation for making any changes in their voting laws, had made enormous progress over the years in terms of registration of minority voters. The numbers no longer justified singling out those states and counties for special treatment, said the majority. He clarified that we issue no holding on Section 5 itself, meaning they weren't striking down the whole concept of the pre-clearance obligation. They were invalidating only the coverage formula, the fact that the pre-clearance obligation continued to apply in 2013, largely on the basis of statistics from the 1960s and 1970s. Congress, he said, may draft another formula based on current conditions. As of now, it hasn't done so. All right, with that, let's go to my colleague, Professor Zeldin, who will talk to you about the history of voter suppression in America.
Thank you. Thank you for having me here. As a historian, it's often our task to provide context for the current events of the day. And that's what I'm going to try and do here. When we deal with the issue of voter suppression, we're dealing with such things as limits to registration, access to polls, voter ID, limiting the hours or placement of polls, and of course, the felon disenfranchisement. What I like to do is point out that there's nothing new about any of these. In fact, I used this phrase in a paper that I wrote about the 2000 election and race, in which I called it an old vinegar in a new bottle. And in many ways, that's exactly what we have here. What we have are efforts that follow trends that were a little more explicit, but that were part of the long history. The key element to understand here is that we do not want in this country for everyone to vote. We want for the right people to vote. Now, how we define right varies on who you are. But if you have the power, you can define the right. You can define the proper and the acceptable. At one point in our history, that meant property. The only people who had a stake in society was felt the people who owned not only just property, but real property, land. And then it was weakened to the equivalent of a certain amount of land and personal property. And then finally it went down to the idea, well, you pay taxes. And that's where the poll taxes came in. It was proof that you were a taxpayer and thus had a stake in society to participate in the electoral process. The problem with such things as poll taxes is that there were a lot of people who couldn't afford to pay poll taxes. In particular, it affected groups that the powers that be didn't consider the right voters. Obviously people of color, but also generally the poor. And so by imposing a poll tax, the idea was to exclude people who didn't have a stake in society, or more accurately, who we did not want to have a stake in society. Because if you have a stake in society, if you participate in the electoral process, you have power. When politicians need your vote to win, you have power. You may only have 300 votes in your particular group in a particular district. But if the election is within 300 votes and your group has those 300 votes, you have power to get government to work on your behalf, to get government to listen to you. So I've been yelling at my students, all the millennials, on the need to vote. Because if they don't participate, no one's going to listen to them. Well, the thing about the poll taxes is that they excluded people who the elites who ran the political system didn't want to participate. In the South, the focus was primarily African Americans. It also would affect poor whites as well, which after the populist movement, they were more than happy to allow that to happen too. Because one of the things that scared the South so much about the populist movement was the possibility of poor whites and poor blacks getting together and voting their class needs as opposed to racial biases. Now, to make sure that a poll tax was effective, because in many states the poll tax was $1.50, they made those poll taxes additive. If you didn't pay this year, next year you owed for 2 years of poll taxes and 3 years of poll taxes. So at a certain point, you were never going to be able to vote. That was why it's so important to get rid of the idea of the poll tax. That economic wealth becomes the determinant of your ability to participate in the electoral process. Why is that important today? We just heard there's a constitutional amendment that says you cannot have poll taxes. That your ability to pay is not and cannot be a requirement for your participation in the electoral process. But as Justice Earl Warren said in the case of Allen versus Board of Elections, there are the obvious and then there are the subtle forms of voter suppression. And that's where voter ID comes in. Voter ID requires money to acquire. You pay for your driver's license. You pay for your gun permit in Texas. Often the ones you don't pay for, the IDs you don't have to put money on, or say a VA card or other forms of identification, they exclude as not being safe enough, accurate enough to prohibit voter fraud, voter impersonation fraud. You go to the poll place and pretend to be somebody else and vote. In Florida, we average about 3 to 5 cases every 6 million voters. And in most cases, we find those are actually mistakes on the part of people running the elections, in that junior signed where senior voted is on senior's line. The one place we know where there's voter fraud, which is absentee ballots, none of this covers. But why is voter ID a form of vote denial, a form of a poll tax? And the answer is because it costs money not just to acquire the ID, but to prove who you are to acquire the ID. Many states have laws that say, we'll give you a free ID. Just come on in, we'll give you free ID. Of course, you'll need your birth certificate, you'll need proof of residency, you'll need things that if you do not already have them, you will have to purchase them. And then, of course, you have to go to the DMV to do it. I don't know about any of you, but the DMV is a place I try to keep away from as much as possible because, well, let's see, they waited 5 hours to vote in Arizona recently. By DMV standards, that's a quick day. The problem here is that states are gaming the system, something that, again, in the past was the norm. Georgia had a wonderful law. This was in the days when you didn't fill out a ballot, but you actually dropped a blue or a white or whatever ballot into the ballot box. And they said that every race had to have a separate ballot box. And you had to drop your ballot in the proper box. Well, if you're illiterate, how do you know which box is which? Like someone comes out and says, it's this one, this one, this one, this one. By the time you get in, they move the boxes around. All in an effort to keep people from having a vote. Because if you put it in the wrong box, your vote was denied. It was an undervote. It was a spoiled ballot, as they call it. Well, with voter ID, what we have here is the impossibility of getting the ID. In Alabama, they have closed, I think it's a majority of their DMV offices. Now, they're doing it for the most important of reasons. They're broke. They can't afford it. Of course, they're doing it in the areas which are where you have the most poor and minority voters, the rural counties. In Texas, you have to drive on average 200 miles to get to a DMV office. Now, remember, we're talking people who don't already have a driver's license. How do they get to the DMV office? 200 miles. It costs money to get there. You wait in line, they tell you have something wrong, you have to come back the next day, and before you know it, money has been spent, required for you to get the ID that you need to participate. So voter ID, and I believe Justice Stevens has admitted it as a factual matter now, is a form of voter denial. It means of keeping voters from voting, a form of a poll tax. That argument is being made before the courts. It's had limited impact, but one of the things that the Indiana case allowed was for you to prove that there was actual discrimination and a burden imposed by voter ID. And that's what's being litigated, for example, in Texas, where 3 courts have ruled that the voter ID requirement in Texas is a burden, not only on voters, but a burden with a specific disparate impact on minorities. In this case, disparate impact is adequate when matched with it being a burden on the right to vote. So, old vinegar, new bottle. It may not affect as many people as the old system did, but it affects plenty. And remember, it's not how many people vote, it's how close the election is and whether your vote was counted or not. If anyone knows about close elections, it's those of us here in Florida, where everyone pretty much agrees the intent of the Florida voters in 2000 was to elect Gore as president, probably about 10 to 20,000 vote margin. But in terms of votes you could quantify, you could actually count, it was so close we were fighting over how to flip the coin. Other forms of voter, in this case, dilution more than, actually it is even denial. But it's sort of a bit of both. Let's talk about the act of voting. You have your ID, you can vote. But where do you vote? Historically, polling places were placed in the South, in stores that were owned by people who were often known to be opposed to African American voting. In other words, you literally took your life into your hands to walk into the polling place and vote, if you were a registered voter. In the South, of course, 95-99% of blacks couldn't vote. They couldn't register to vote. In Florida 2000, the U.S. Commission on Civil Rights looked at the other scandal in Florida. Not the hanging chads per se, not the question who became president, but the fact that there was a disparate impact of spoiled ballots based on race and wealth. It turns out that there were lesser numbers of machines placed, for example, in Miami-Dade, in minority precincts, and they got the old machines. Now, the problem with the old IBM machines is that there's a piece of rubber that you push against when you're pushing out the chat. And as that machine ages, that rubber gets stiffer and stiffer, as rubber will. And that's why you can push and get an indention, but not necessarily knock out the chat. So you have penetration, but no actual vote. It's merely a pregnant chat. And by the way, there is a line of discussion using these terminologies in the first federal case to hear the Florida argument in a Miami district court, where the judge says, so let me get this straight. You can have penetration without, oh, we will go. The point here is that having machines that don't work meant that these areas had a larger number of spoiled ballots. And a spoiled ballot is any ballot you can't determine who the person intended to vote for. That's the problem. You know what's happened you've all, I'm sure, heard what happened in Arizona. By the way, in North Carolina, they also have long lines, and they did their presidential preference by primary. But 5-hour waits. Why? Because they went with open voting. You go to any voting polling place, sort of like we have with our early voting. And they took the normal 800 polling places that they, by the way, they're going to use for their regular primary and for the general election. And they lowered it to 60 polling places, in which you could pick where you wanted to vote. An average of about 25,000 voters per precinct, polling place. Now, I don't think this was intentional. I think this was, with all due respect, an error on the part of the people who run the elections. They miscounted or they misestimated the number of people who would be voting live. And they misunderstood the time involved when you have open balloting, something they're not used to doing. And more important, when you have primary voters who are coming in who are independents who have to be told, no, I'm sorry, you can't vote. But I know I want to vote. No, you can't vote. Well, let me vote provisionally. all takes time, it slows down the election process, long lines of the results. Now this can be done with more intent. Back in 2004 in Ohio, Kenyon College got one voting machine. Every student who was there to be registered locally wanted to vote. 12 hours later, they got it. And they stood there for 12 hours. Oh my God, they had a really good party at the time. They were so angry that they had fun with it. But the point is, they had 12 hours because there was one voting machine. Despite the fact that there were a couple thousand students who were registered in that precinct. Vote. Let's talk about registration, making it hard to register. Now today, we try and make it as easy as possible to register. There are registration forms, lots of education efforts. The voter says that you should be asked if you want to register to vote when you get a new driver's license. But despite that, people find it difficult to get registered. Or they register, and then they find that they've been dropped. In North Carolina, any registered voter can challenge the registration, and hence the vote, of any other registered voter within the precinct. Which means their vote at best becomes provisional. And provisional ballots is an iffy thing about having your vote getting counted. Historically, this was the main way you kept people out of voting. You just never let them register. In Chicago, in the Progressive Era, you had to register to vote on one day. I think it was 7 weeks before the election. There was then a 3-week period in which your registration would be challenged, and then there was a 2-day window in which you could defend your challenge. Yeah. The purpose here, of course, was to make it almost impossible to register, and the aim, the focus there, was on immigrant voters. In the South, they made it simpler. They just made it impossible to actually register. At first, it was explicit. Rules that barred you from registering to the Democratic Party through the white primary. Literacy tests. Understanding clauses. And what they do every time the Supreme Court would not say, no, you can't do that. They would just simply make the law more race neutral on the surface. Everyone's affected by this, not just people of color. Of course, the people who made the decision as to whether you passed the test were the clerks in the registrar's office. And the old joke goes, and with way too much validity, that a black man walks up to vote, he's asked, please explain the First Amendment. Oh, no problem. I wrote my master's thesis on that. Oh, okay, here's your second question. Please explain the supremacy. That was my dissertation topic. Okay, one last thing. This is going to be a literacy. They go to the bottom of the drawer, they open it up, it squeaks, and they pull out a piece of paper that's real dusty, so when he shakes it, dust goes everywhere. And he hands him a copy of the U.S. Constitution written in Mandarin Chinese.
Oh, God.
What does this say? No Negroes are going to vote in this year election. Now, that's an exaggeration of the reality. But if online, many of you might have seen some of the voting tests that you had to take, your understanding tests. Most of us would not be able to pass it. Of course, whether you passed it or not was determined by the people who made the decision. So we decentralized disenfranchisement. Well, we've got a lot of problems with registration in this nation today. Limiting the hours in which you can register, the requirement of voter ID as part of the registration process. All of these things have a long and nasty history in America. All coming down to the simple fact that in America, we do not want everyone to vote. We want the right people to vote. It's just a question of how you define the right. Oh no, by the way, dirty little secret. Republicans obviously want to shrink the electorate because their voters are high saliency voters, they turn out to vote. Small turnout means they're likely to have more voters who vote Republican. Democrats want an election that includes everyone, because when you increase the number of voters, especially on the margins, they're more likely to vote Democratic. So in this case, neither party comes off clean in this. They're self-serving. It comes down once again to who are the right voters. My own answer? The American people. Unfortunately, that seems to be a minority view in many states. Thank you.
Now, once again, Howard Simon.
Well, I want to try to be as short as I can, so we can get to some discussion and questions. I just want to list some issues. The major issues about voter suppression that are occurring now are in the courts involving Wisconsin, Texas, and North Carolina. North Carolina may be the major one, and where we are involved in all of those cases, and a decision may be coming down from the federal district court in North Carolina now, I think, any day, and that is the most significant case because that is every form of voter suppression that is conceivable was enacted in the North Carolina statute restricting same-day registration. It was also a gerrymandering issue, reducing the number of early voting days, early voting hours, and so on. I want to mention one other way in which that was also alluded to by the professor about the way in which your vote counts less, not only if you are denied the right to vote, but on the issue of vote dilution. And we've had some good examples of vote dilution in Florida. The most important one, I think, is the Fair Districts battle. And the Fair Districts battle was one in which, though you had the right to vote, your vote would not count as much because all voters of one race or one party would try to pack as much into one district as possible. So you could have a right to vote, but your vote would not count as much. There is a very interesting, 1 week ago today, we won a federal lawsuit involving a North Florida county that establishes, I think, another principle to attack vote dilution. And for the first time in the country, we won a case involving vote dilution with regard to prison gerrymandering. And if you know, most of North Florida, the main business in North Florida are prisons. And we filed a lawsuit against one county in which the county commission there were 5 separate county commissions in Jefferson County. And in one of those county commission districts, there is a prison. And there are thousands of prisoners in that prison. And they all counted for purposes of proportioning the county commission districts, but of course prisoners did not vote in Florida, which means that the non-prisoners in that district, the value of their vote was 20 times greater than the value of the vote of any citizen in any other district. So this was a very important lawsuit we won. A similar case with a crucial difference that I don't want to get into now is pending now before the U.S. Supreme Court, also out of Texas. But in our case, the issue isn't whether prisoners should be counted, but where prisoners should be counted. Of course, prisoners should be counted. They should, non-immigrants, children, all non-citizens, everybody should be counted for purposes of apportionment. What we argued and what the federal judge agreed with us about was that the prisoners should be counted from where they come from, in the districts where they live, not where they are temporarily, involuntarily sent, namely to prison. So after the next census, if we can defend that principle and then extend it to state legislative and congressional districts, it'll have some impact as well. I don't want to steal all of my friend Desmond's thunder, but I want to say a little bit about felon disfranchisement, which is, I think, the estimates vary, but it's somewhere between 1.5 million and 2 million people. I'll let Desmond talk about the problem with that. Now, I want to talk about where it came from, because I think if people knew more about where it came from, more people would be outraged. We would be able to get rid of it and drag Florida kicking and screaming into the 21st century. The problem with felon disfranchisement in Florida is that when Florida, a member of the Confederacy, lost the Civil War and was forced to rejoin the Union and had to extend all the rights to the freed slaves, the founding fathers of Florida met in Constitutional Convention in Tallahassee and in 1868, and they were faced with a big problem. They were forced to extend all the rights of citizenship to the freed slaves, but oh my God, there was a big problem. In many places in Florida, there were more freed slaves than white people, and if we extended the right to vote to all of them, they would take over. So we had to figure out some way to take the right to vote from as many black people as possible, and we got the expansion of felonies, we got the expansion of a number of felonies, and we got the expansion of lifetime felon disfranchisement, and 148 years later, that's exactly the way in which the system continues to work. The 2013 case by the United States Supreme Court in Shelby County, Alabama, was a disaster for the Voting Rights Act. I mean, I think it was a disaster philosophically, politically, for voting rights, personally. I worked in the South. I was there marching from Selma to Montgomery for the passage of the Voting Rights Act of 1965, and to see it be ripped out of Section 5, the pre-clearance section, the heart and soul of the Voting Rights Act, ripped out of the Voting Rights Act was, I think, devastating. Some of these states, like Texas and North Carolina, within hours after the Supreme Court ruling, enacted their voter suppression laws that are now being challenged in court. We were part of that lawsuit. Our legal director represented the Alabama NAACP and voters of Shelby County, Florida, in that losing effort. But I'm hopeful, because one thing I think we all have to, there are a couple of dirty little secrets about our system, one of which we'll talk about later, but what I want to mention now is that, cases are won in law. It's like baseball. When the guy on first base tries to make a steal in home, and the catcher throws the ball down to the second baseman, and the second baseman swipes with his glove and gets this guy out at second base, and he's called out. Why is he out? Was he out because the ball got there first? Was he out because the second baseman swiped him before he touched the base? He's out because none of those things are true. He was out because the umpire called him out. That's the only reason that he's out. The umpire won. And the Shelby County case was one in which the umpire decided, for partisan political reasons, because now virtually every institution in America has been made a partisan institution, including the United States Supreme Court, found that Section 5 and Section 4 were no longer open. I want maybe a little bit of disagreement that there was not an update. There were hundreds of pages submitted to the Congress about continuing discrimination in those jurisdictions that were covered jurisdictions, especially in Shelby County, that established the continuing need for this pre-clearance provision of the Voting Rights Act. But this was kind of like a lost cause from the outset, because it was a long dream of those who want to try to restrict the right to vote. What I would like to talk about, and I'm anxious to get into to hear from Dr. Snipes, the supervisor, are ways in which we can figure out how to expand and get more people into voting, and there are ways. She's going to be charged with implementing a state law that the legislature passed, but of course, given our legislature, it would not go into effect until electronic voter registration. And registration is the main barrier to voting. I mean, you can't vote unless you're registered, so we have to expand the number of people registered. We expand the number of people who can vote. But there are other things that we can talk about that are still permitted under law. For example, I'm curious as to what goes on in Broward County, and the supervisor can inform us. There are, I think maybe 38,000 people in county jails in Florida. Most people in county jails are in county jails, not being able to have made bail, awaiting trial, presumed innocent, have not lost the right to vote. That's now an arrangement, I presume, between the supervisor's office and the county sheriff about ensuring that people who are in jail at election time can cast an absentee ballot and be able to vote. There is a provision, and I want to hear the supervisor educate me about that, that allows, I forget what it's called, but it's got like pre-registration. Students can pre-register in the schools, and then that registration becomes automatic, I believe, when they turn 18. What can we do in the public schools to register, to pre-register more students? One of the things we ought to think about, I mean, it's a pipe dream in Florida, given the fact that voter laws in Florida are controlled by partisan ramifications. But the most effective thing that we could do, if we were able to have the power, would be same-day registration. So that would be the most effective thing. So those are some of the things that I want to make sure that we do talk about. There are limited opportunities, given the fact that voting in Florida is hostage to partisan considerations. But there are things under current law that still would allow us to try to expand who's registered and who can vote. For example, in 2011, the legislature passed what we call the Voter Suppression Act of 2011. It resulted in at least 6 lawsuits from the ACLU challenging all of that in terms of voter registration and so on. But it left the supervisors with the complete authority, I think, not even overseen by the county commission. I think the supervisors have complete discretion as to how many early voting days and early voting hours. And so I presume the supervisor, like Steins, will be utilizing most of that. So anyway, that's one of the things that we should talk about. What are the opportunities to expand registration and expand voting?
Thank you, Howard. You have provided the transition to our next speaker.
I actually think I should be packing my bag and taking a break. I was trying to keep up with all of the things that were listed that do directly involve the supervisor elections. And one of the things that I'm most proud of in Broward County, and I'm happy to respond to your question regarding what we do for the students. On an annual basis, my office goes into the schools to set up registration in all of our high schools in Broward County. That's private, public, and charter. And we have been very successful in maintaining the bond that we have with the school board. And for the pre-training opportunity for the students who are going to conduct the registration in these schools, we conduct the training via the school district's beacon television system. So that way we are assured of getting the same information to every school in Broward County who can gain access to that beacon operation. So that way we get information into the schools prior to going into registering. To make a long story short, in the registration that we held in January, which was a very tight process, we registered over 14,000 students in Broward County, which meant that part of those students were pre-registered. So when the child, if they are registered, if they're now 16 and are pre-registered, when they turn 18, they will receive a voter information card from our office as well as a birthday card, just congratulating them on having been a pre-registered voter, now eligible to vote in the next upcoming election. So that's something that we've stuck to. I've been here 13 years. And we've done this just about every year since I've been. It's very successful. You mentioned early voting, which is one of our, proudest ways of voting, but it's one of the most popular ways of voting. And most of you will remember, especially if you're from Florida, is that in 2012, the legislature made many changes to early voting. It made it very difficult to operate in the ways that we have become accustomed to operating in Florida. Initially, when early voting started, I think we had up to 14 days, and we were always sort of limited in terms of the types of facilities that we could utilize. But 14 days gave us a lot of opportunity, and we could add as many hours in that day as we chose. However, in 2012, that changed. We were limited to 8 days, 8 hours, to our offices as potential locations, city halls, and public libraries. But we could only make it available for 8 hours. It caused a disastrous voting experience because we had persons wrapped around the buildings that we could use 3 times deep. And I have to say, all of the onus fell on the supervisor of elections, and it was erroneously placed there because the supervisors that I know in Florida are very committed to doing an outstanding job for their voting populace. And a lot of those things that we went through in 2000, I think most of those from the standpoint of the supervisors, we're on the ground, we're the implementers. So we implement Florida law, but when you have all of those restrictions, there is a limit to what you're able to do and to do officially. So after 2012, many of the legislators wanted to hear what some of the larger counties in particular experienced. So several of us traveled to Miami-Dade to make presentations, some to Tallahassee, and Senator Latvala, I believe, who was over the commission that dealt with voting, made a statement at the Performing Arts Theater in Broward County. He said there's enough blame to go around. So immediately following that, in the next legislative session, all of those restrictions which had come to pass in 2012 disappeared. We now can have early voting up to 14 days. We may have early voting up to 14 hours, still in the same locations, plus community centers that have a footprint that will allow us to establish enough equipment so that we don't have an Arizona kind of a situation. So we have the up to 14 days, up to 12 hours a day, Saturdays and Sundays. That was one of the things that was cut out in 2012 was that last weekend, Sunday of the last weekend. So that has been reinstated, and we're already using most of those things to get early voting back up and widely available to individuals. And in terms of how we select our early voting sites, first we want to know that a site fits into the requirements of whatever the legislature has established, but there's also a wild card allocation in this whole process of selecting facilities. And we had difficulty finding a location on the east side of town, because that's where most of your older facilities are. So we used our wild card to establish a early voting site at Coral Ridge Mall. It has worked out very well. We've used it for 2 election cycles. Haven't used it in the primary this time, and we're getting a good turnout of voters there, and we'll use it again when we get to the local precinct, as well as the general election in November. But we use 20 early voting sites, and we categorize them as small, medium, and large, letting us know about how many people we can get through an early voting site during the day. We publicize that information to our voters so that they have a sense of, if I go to this location, it's going to be closer to my home, but it's a smaller footprint, so I may choose to go somewhere where I know there's going to be to a location that's identified as a larger site. Parking is one of the issues that we consider. If we have a small facility with parking that is very limited, such as our David Cooper City location, that location is on a small plot of land, and right across the street is a deep and ominous canal. So we don't want to have too many people go there because parking is so limited, and when they go and park next to the mail, it's dangerous. So as supervisors of elections, those are the kinds of things that we look into prior to establishing a site. Is it easy in and out? Is it going to be used for anything else at the time we want to put early voting there? And also the inclusion of that last Sunday. It is traditional in the African American community in particular. They like to go from church to the early voting site, so we think about that in terms of the number of hours that we make available for our early voting voters. And you talked a little bit about registration. I think there's something that we need to look deeper into. In Broward County, we have 1,103,000 voters thereabout. In the last primary election, we had about 290,000 people who actually voted. So the percentage, I think, once we were able to count all the votes that were eligible to be counted, then we had turnout of somewhere around 36%. We could have had a bigger turnout if some other conditions existed, such as voters who did not sign their absentee ballots. The way we verify voters' eligibility to submit an absentee ballot is through the signature verification process. And by the way, my staff has been trained in signature verification, so I'm comfortable with their ability to review a signature and determine that it is appropriately written by the person who submitted the ballot. We acknowledge that, there's anytime you make a law or procedure, there's always someone who's looking to get around it. That's where hacking comes from. But I can say that we don't have many challenges of folks who say, I did not sign that ballot. If a person says that, we're going to go deep into their record to look for the signature, because we want every voter to be able to maintain a level of confidence in being able to vote and feel like their vote counted. So if we've been able to count those 681 ballots, I believe, where the voter did not sign, and what we have in place now, the legislature's been coming around a little bit. There was a time when we could not count those ballots, but now we have a provision in place. If you get a ballot, there's no signature, you may notify that ballot with that voter with an affidavit to say, please send us your signature, picture ID. We're going to get your signature on the ballot. We'll attach this to your ballot envelope. After having checked your record to make sure that's your signature, that ballot can be counted. We could have also had more voters if our voters had gotten their ballots into the mail a little bit early. I think we're up to about 1,000 ballots that came back after election day. And we cannot use postmarks. So those ballots that came back, the voter had good intentions, but it was ill-timed in some cases. And we haven't looked into everything to see if it was a post office issue, if we don't know what time they got it to the post office, but we do make drop sites available. We had 13 drop sites available this year in the different early voting locations. We have drop sites in our offices downtown as well as our voting equipment locations. So our goal as supervisor of elections is to make the voting process as pleasant for the voter as we possibly can. However, in this past primary, everyone wasn't eligible to vote because we have a big group of people who reside in the ENPA. That means that for the primary, they were not eligible to participate. So we can't just look at that particular election and say, well, that was a low turnout. But when we get to the general election, all of us in this room, whether you're from Florida or not, Broward County or not, we need to encourage folks to vote. We need to let them know that it's okay to come and vote, that your vote will definitely count. We can't count what we don't get. If we don't get a vote, we can't count a vote. If we get a vote and it's late, we can't open the envelope, so we definitely cannot count the vote. So our turnout is not where I would like for it to be, but the role of the supervisor of elections is to do a voter registration component, do a voter education and outreach component, prepare the ballot, conduct the election, and then overall educate our voters. But I believe, we've been doing some research on this, and I know there are professors up here and attorneys up here who probably also do research, but what we're finding in the readings that we're doing about turnout is that turnout is generated by candidates and issues. And I really think we saw that in this primary election, because even though the numbers were not where I'd like for them to be, they were larger than they have been in some primary elections. And this election had so much electricity in it, that and so much energy that you can't sit home and ignore it, mainly because of the candidates. So I'm hoping as we go forward, we can, in our education process, we can talk to our voters more about the rationale behind the vote. I grew up in Alabama in the 60s, and I don't think I have to say much more than that. So I saw things firsthand, and I know how people were denied the opportunity to vote. I didn't get a chance to go to Selma, but I did see the film. I saw it with my staff because I want them to understand the history, some of the most recent history that relates to persons' inability to vote, not because they're not interested, because there were structures in place at the time which did not allow them to vote. I can remember my uncles and my aunts wanting to vote and not having that opportunity. So I come from the South as a black child of the South. So I kind of have two advantages to really understanding the importance of voting. So it's disheartening when you get out, you put out a sample ballot, you take your little equipment around in the community. We go to every festival, we go to every parade, we go to every school, I already mentioned that. We go to every opportunity, we go to every football game, we call it Friday Night Lights. We put this information out, and if you live in Broward, watch for the big county bus. It has a sign on it as big as this room, with the election dates, encouraging voters to get themselves ready, to check their status, to make sure that you are voted, to look for your voter information card. If you don't have it, call us, we'd be happy to send another. We have even, I recently, in the last election, had a woman who called and said, I can't get there. I don't have a car, and I want to vote absentee because at least I can get the ballot at my home. I personally picked the ballot up. I'm the supervisor of the election. I picked the ballot up. I brought it back in. It was signed in. I had to sign it in. If you drop off a ballot at this supervisor of the elections office that belongs to someone else, it is not going to be accepted unless you sign it in. I don't consider that a barrier. I consider it an advantage and accountability structure. So that if you bring me 5 ballots, of course they don't all belong to you. I want your name on a list that tells me that you brought in these ballots, so I get your printed name and your signature to know that these ballots came from this individual person. We try to put as many safeguards in place as we possibly can so that voters will feel like if I put my vote out there, my vote is going to count. As it relates to provisional ballots, that was another thing on the list. The provisional ballots work fine if the voter is registered in this county. If a person is not registered and they go and they say, go out to precinct 8001 and say, I'm a registered voter, I'm registered in this precinct. If our records don't show any evidence of that person being a registered voter, then they have 2 days by law that we have to wait for that person to bring in any kind of proof that they are indeed a voter. We will go through their record, we're going to check everything that we have, and we do collect images from voters. If they write to us, we collect those images. We have an image of their voter registration form. We have a record of how they voted in terms of whether they voted early or what have you. And so we check all of those records. And if the voter brings something in to us that's credible and we did not have a record of that, that provisional ballot is going to count. We touch every single provisional ballot. We got many in this election. I recall over 600. Because voters went to the polling place, we could have just said, our records show you are NPA. But instead of doing that, we say our records show you are NPA, not eligible to vote as a Democrat or Republican, but we'll offer you the provisional ballot. giving that voter the opportunity to come back to check their records. We did find some voters who had indeed been a member of one of the major parties. So those are the kinds of things I'm seeing. There was a long list of things here. We don't throw any votes out. Some voters think that the only time we count an absentee ballot is if the race is close. We don't even know if the race is going to be close or not. So our best bet is to count the absentee ballots at the time period that's allowed by law, which is 15 days out. So 15 days out from an election, we're going to be processing those absentee ballots. And I have to brag on my location, and I would invite anyone to come over and see it, you in the audience and the panel members, because we do use technology, I think some of the best that's out there on the market, to help to first identify the voter and match the voter with their ballot style. Everybody in here can belong to a different precinct. That's probably a different ballot style. But we identify that voter through the file that comes right out our live database. We pick the ballot that goes with that person's precinct. It's packaged into an envelope. It's sorted as it goes through our outbound machine. When it comes back in, it's again put through our inbound machine. We crop the person's signature, then we send that ballot so that we can verify that signature. But it takes all of the manual activity out of the packing and the verification process when it's going back to the machine. So I think we have a lot of things in place. We're not, I wouldn't call it a model location, but we sure are a hard-working location, making every effort to take care of the voter. We do other things related to the election process, but the voting is a key component of that process that we really place a lot of emphasis on. In terms of the felons, we follow state laws that relates to felons. When a person votes, and it's important for everyone to know that a person's voter registration strikes against several databases in the state of Florida. And if a person is found to have had a felony record, then we get notification of that. We notify the voter, and a lot of times, the voters aren't reading the persons who identified as a felon. They're not reading the newspaper. So I think it would be much more beneficial if we could put their information on the website, just a list of names, we put them in the paper. And rarely do we get a response from a voter. Sometimes I'll vary and put the names in the paper and community paper, because there may be a mother, a parent, an aunt, an uncle who sees this that they may not see in one of our major papers. But still, we don't get very much response for that. So I'm real eager to hear our next presentation. So we have, over the time that I've been here, we've removed tens of thousands of persons who have felony convictions without their rights restored. We've removed them from our voting rolls. When a person is ineligible to vote, there's a 90-day cycle of time that is in place for us to contact the voter. That's 30 days. The voter contacts us, that's 30 days. And then if the voter requests a hearing, that's a 30 days. So don't just go in and strike through a person's name in the database. There's a process for that. And we do have persons who are removed because they're deceased, persons who are removed because they are non-citizens. But we try to keep compliance as our main guide for what we're doing so that we can be fair to everybody. And I wrote down a lot of things here. I think I've tried to hit on all of them. Voter fraud, I think is very rare. We might see 2 or 3 people per election, and of course we send those names to the state's attorney's office. And one of the most recent I can recall was an 80-year-old woman who lives in Broward as well as somewhere in New York. And she voted, she owned property in New York, and I don't think that's a part of our law. But the state's attorney's response was she owns property in New York. She's 82, for God's sake. So so much for fraud. I can honestly say we don't have a lot of those cases that we have to send to the state's attorney's office. And in this woman's case, she thought that, well, since I own property in Florida and I own property in New York, and I voted in two different types of elections, how did I commit voter fraud? And it's not clearly identified for us in the statutes, from what I can understand of the statutes. So, I don't think there would be anything else that you would need from me.
Last but not least, long last, Mr. Desmond Nees.
So good afternoon, pleasure being here. I know we're a little bit behind schedule, so
Take your time.
you heard it, right? All right, so I think my purpose being here, at least primary purpose of me being here, is so that the audience could actually hear from a person that is directly impacted by these policies. So I'm an individual that I've done some wrong in my life, and eventually in 2001, I was actually sentenced to 15 years in prison for possession of a firearm by a convicted felon. Probably all of my felonies other than that were associated with my ongoing drug addiction at the time, and eventually it led to me being homeless. But while I was incarcerated, I was able to work on my case, and I managed to have my case reversed and remanded, where I was able to take a plea deal, and I was released in 2004, the end of 2004. I tell people that I was released from prison, but I was still entrapped in drug addiction, and eventually that drug addiction led me to be homeless again and again and again. Released about 3 or 4 times in 2005, until eventually in August I found myself, in South Florida, standing in front of railroad tracks, waiting on a train to come so I could jump in front of it. Homeless, hooked on drugs, recently released from prison. The only thing I owned was the clothes on my back. And so I didn't see that light at the end of the tunnel. I didn't have any self-esteem, and I wanted to just end the misery. I was tired of it. It's a cycle. Thankfully, the train didn't come that day. For some reason, I don't know why. But I guess I kind of know why, right? Why I'm there. But the train didn't come that day, and I crossed those tracks. And I walked a couple blocks further and checked myself into drug treatment. And after I completed that, I moved to a homeless shelter. And while I was living in the homeless shelter in downtown Miami, I decided to enroll in Miami-Dade College. Really do something to help, raise my self-esteem. My whole purpose was that I just didn't want to use drugs anymore. That was it. I didn't see anything else other than I just didn't want to use drugs. So maybe getting an education would help me. I ended up enrolling in the paralegal program because I did a lot of legal work while I was in prison, and so eventually I did graduate at the top of my class with that, and I was encouraged to continue my education, which I did. I pursued a bachelor's at Miami-Dade College in public safety management with a concentration in criminal justice. I figured since I already had the experience on the street, I'd go back to academic, That turned out to be a good choice because once again I graduated with highest honors, so I must have known what I was talking about. And eventually I was accepted into the law school. I chose FIU College of Law, and in May of 2014, I graduated with my Juris Doctorate degree. You know, and typically, when I say that, the audience normally, gives a round of applause that this homeless man just announced that he, earned a law degree. You guys will feel hard proud. Typically, the audience do. And typically what I tell them is that my story does not have a happy ending because, in spite of these obstacles that I've been able to overcome and the accomplishments that I've had in my life, that I still cannot vote. And beyond that, I can't, I'm married with kids and I can't purchase a home anywhere I want because a lot of HOAs have restrictions written within their provisions that would bar me from owning or even renting a home. I did well in law school, but eventually made the dean's list before I graduated. But I still cannot practice law in the state of Florida because I can't even apply to the Florida bar until my rights have been restored. And so, if it was just me or if it was an anomaly, yes, maybe it wouldn't be that big of a deal, but I think Howard alluded to it. But we have a lot of people that's in this category, in 2010, I know that the last comprehensive study that was done indicated that over 1.54 million people could not vote because of a prior felony conviction, and that was in 2010. I can safely say that each year after that, an average amount of 170,000 people each year have been convicted for felony offenses in the state of Florida. And so I strongly believe that that number is nearing 2 million mark. Because of course we factor in the repeat offenses and stuff like that, and I was very intrigued by the 54% that Howard was talking about. But what adds to that number is prior to 2011, the 4 years prior to that, and you've heard the numbers earlier in the presentation, that 155,000 people, or say an average of 38,000 people a year, were able to have their rights restored. I think that first year in 2011, a total of 78 people had their rights restored. So what we've seen from 2010 to now is that while we've seen an increase in the amount of individuals in the state of Florida who were losing their civil rights due to a felony conviction, we've seen at the same time a drastic reduction in the amount of individuals whose rights were restored. And so that led to the argument that we feel that that number has grown significantly from over 1.54 million in 2010 to almost 2 million in 2016. And so I count myself among those individuals who, have been denied citizenship status. I'm a firm believer that probably the ultimate ingredient or the DNA of citizenship is the ability to vote. And if an individual does not have that right or that ability to have their voices heard, then I think they're relegated to second-class citizenship status. And it's extremely disheartening considering the fact that we have served our time. I have served my time. Whatever my punishment was, I did it satisfactorily, and I went above and beyond. When I talk to people and I share my story, I often have to remind them that no American citizen should have to go through the lengths that I've gone to. A person should not have to go to law school and get a law degree to earn the right back. You know, I don't think that those qualifications should be in place. I think personally, I don't think you should ever lose your rights. You know, I tell people I have 4 boys, 1 girl, and if you have boys, you know sometimes they can do some boneheaded things. And, you know, mine, every day is something to do with mine. And, but they taught me a lesson because, you know, every now and then they would really do something to really piss me off. And I would put them on punishment. But when I do that, I'm reminded that no matter what they did, they never stopped being my son. They never stopped being me. You know, I'm gonna punish them and they're gonna complete their punishment, but they never stopped being me. And I think that should also be true for American citizens. That no matter what you do, you know, you should not lose your citizenship. You should never have that right to have your voice heard taken away from you. You know, and so, but I know that, you know, there is probably, as a matter of fact, no, I can definitely say that there is no other organization in this entire planet that I am more proud of than the ACLU and its support for our efforts. You know, I heard somebody say that Howard Simon was the best thing that ever happened to the ACLU Florida. Someone said, I know I heard it. and I kind of agree with that too. I've enjoyed that companionship. And the reason why I'm saying this is that, no, I'm not going to ask them for money later. But I'm saying it because I appreciate the fact that the ACLU have all of the basics locked down. And I don't necessarily have to get into all of the basics. But I want to really come from a perspective of a directly impacted person that is on the ground every day having conversations with other directly impacted people, leading other directly impacted people in communities that's mostly impacted by these policies. And so I may not rely heavily on, I think Howard mentioned a group in Washington, D.C. What was the name of the group? Yeah, the Urban Institute. And I may not rely heavily on some analytical guru in New York or D.C. or California. What I'm speaking from is from right here, from what I see with my eyes, what I hear with my ears, on the ground. And I think that that's something that statistics just can't relate to in real fashion. That's how I feel. So, part of the problem that I believe that we have is that when we look at this issue, we look at it as an issue that impacts those people, and not necessarily as an issue that impacts me. All right, and I think that when we do that, all right, we temper the level of involvement that we should have. Now, when you look at this issue on its surface, with the amount of people that's being disenfranchised, I would allude to it, we should be dragging Florida, kicking and screaming, into the 21st century. But we have to ask ourselves, why have we not done this already? Well, I beg to differ. I beg to differ on that. Because I can tell you this, you know, one of the things that, you know, I kind of like push back a little bit, just a little bit against, because I know that this policy is a tool that is used to manipulate or suppress the vote. But I think it's true on both sides, right? And I tell people that when I hear the rhetoric that, well, you know, Republicans don't want to restore people their civil rights because they know that people in prison typically will vote Democrat. You know, I kind of cringe at that because, in a sense, that's saying that the only people that commit crimes and go to jail are Democrats, right? And I know that there are a lot of Republicans. I travel this state on a daily basis, and you know, I just got through interviewing a few Republicans, all right, that were in prison that want to have their rights back. You know, I think that the issue, while its original intention, all right, were to suppress the political activity of newly released slaves, right? I think that because of our infatuation with incarceration, that this policy is in the transcending political lines and racial lines. Now, typically, for instance, I give a prize because I always ask a couple questions of my audience. I like interaction a little bit, and I do have a prize. I just don't have it with me, but I promise you, I give it to you. But you know, when we talk about the last known research that was done that indicated that over 1.54 million Floridians could not vote, I just need a brave soul to tell me, out of that 1.54 million, what percentage of them were African American? A brave soul. What's it? 90%? 50%? Oh, so you done messed the bus then. What percentage of that 1.54 million were African American? Gotta give one more brave soul. Give me a number. Yes, sir. All right. So when I give my prize, I never give it to the one who gets the correct answer. I always give it to the one who's furthest away from the truth, so they will never forget how far off they were. And so, ma'am, I owe you a prize because you said 90%. The reality is a little over 33% were African American. So out of that 1.54 million, a little over 500,000, right, were African American. That meant that over a million people who couldn't vote in the state of Florida did not look like me. Guess what they look like? That's what they look like. But what happens is that when we feed into the narrative, and there are multiple narratives that's out there about criminal justice, that African Americans are responsible for all the crime, we're doing all kinds of crazy stuff, you know, and then you're connecting the crime that you're associating with African Americans with fundamental disenfranchisement. And then we hear the rhetoric around, well, yeah, they don't want to let African Americans vote, or they don't want to let people vote because they'll vote Democrat, because African Americans supposedly is the only race of people that we're locked into a party. I don't know how that happened, but that's what we are. But at the end of the day, all of these different narratives form this illusion that the majority of people, this is an African American issue exclusively. We do not lose sight of the fact of the disproportionate impact that it has on African American community. We cannot lose sight of that fact. But when you're talking about sheer numbers right now, when you're talking about sheer numbers, what we see is that this is not exclusively an African American issue. It's an all-American issue. And that's how we have to approach it. Because when we do, we're able to even now make even an economic issue, a public safety issue. I'll show you something. And I would love to see this report. Because I did my little minor research, you know, maybe I should get hired by Howard. But what I've discovered is over the last 4 years, 5 years, over the last 5 years, of all the people that were convicted of felony offenses in the state of Florida, less than 25% of them get sent to prison. Think about that for a minute. Because our dialogue is, yes, let's restore the rights of those people when they come out of prison. That's what we think. But the reality is, there's an overwhelming majority of people who are losing their rights in this state don't even get sentenced to prison. Guess where they're at? They're in our community, in our homes, in our churches, in our pulpits. But when we think that the only people whose rights are restored are locked up in prison, Howard told you, there's only 101,000 people who are incarcerated in our prisons. And it's about another 135,000 that are on probation or parole. Where are those other people? When we start thinking about that scary, violent African-American male that we want to redeem, and start thinking that it could be my son, my husband, my granddaughter, my grandson, that is being denied the American dream, that's being denied the right to have his voice heard, that kind of would anger us a little bit more. When we start thinking about the money, thinking about how, I remember when these policies was first implemented, that that year, just on state funding alone, not with federal subsidies or whatever, but state funding alone, our governor signed a budget that allocated $3,500 to educate each child. $3,500. That same year, we were spending $18,000 of your tax dollars, to house one person, majority of whom were non-violent. Drug offenders that should be in treatment. And if you remember, he told me I had to be quick, right? Y'all remember? Okay, he told me to take my time. But no, I'm gonna, okay. But I think this is very important. That year, the Parole Commission did a study, and it showed that when it looked at, and it studied a little over 30,000 people, right? And the years of 2009 and 2010, whose rights were restored. And at the time, Florida had a recidivism rate of 33.1%. So that meant that every 100 people that was released from prison, 33 of them would go back. When they looked at individuals in 2009 whose rights were restored, what they found was that their recidivism rate was reduced to 12.4%. When they looked at the ones in 2010 whose rights were restored, it was reduced to 5.4%, right? And so basically what that meant was that out of those 30,000 people, probably a little over 27,000 of them, when they had their rights restored, did not commit another offense, right? Became law-abiding, tax-paying citizens, right? That did not go to jail again. What those 27,000 people represented was over $545 million that the state did not have to spend just to incarcerate them. We're not talking about the cost of investigation, where they to commit a crime, or even the cost of supervision, or the cost of the trial, where they get caught, right? $545 million that 27,000 people commanded. That was a budget that was larger than the biggest city in the state of Florida. And if you remember that year, particularly in Miami, when police unions and fire departments were forced back to the collective bargaining table to renegotiate a contract because cities didn't have enough money, and police departments was forced to lay off officers. Fire departments were threatening to cut their force. I think ACLU was going to cut it in a third. That was a public safety issue. And so while you may not have committed a crime, or maybe for some reason you may not even know anyone that have lost their rights, because so much money is being spent on a system right, that warehouses people like me, and because they have a policy that denies me the right to vote, that would help increase the likelihood of me going back to prison, you're being put at risk. You have less police officers, you have less firefighters. If your house catches on fire, they might have to roll the dice to see whether or not they come and put yours out. And so it does impact you, you know, and it should be enough to say, wait a minute, maybe I do need to step up. Maybe it's not just about helping them, it's about helping us, it's about helping our community. It's about really stepping up and trying to take Florida or bring Florida into the 21st century in alignment with the majority of the other states, and do what's right, do what's fair, do what's moral. You know, I end with this, you know, I promise I do. The current policy says that you have to wait 5 to 7 years after you have completed all portions of your sentence. What they don't tell you is the processing time that occurs after that, particularly the 7-year wait. We have people that are still calling that have submitted applications in 2007 and have still not gotten an answer yet. And so you're looking at upwards of 17 years that a person will have to wait after they have completed all of their portions of the sentence. And based on the current rate that's going on now, even after waiting that long, you still stand less than 0.001% of a chance of having your rights restored. And on top of that, if you so much as get a speeding ticket, you could be disqualified. And last clemency hearing, which I attended, a gentleman was in danger of not having his rights restored because of parking tickets. And so I leave you with this, you know, some people say, what would Jesus do and all that kind of stuff. I know I speak to my Christian inner self, and I'm reminded of when Jesus was on the cross. You know, and we're Easter, right? And when he was on the cross, it was the criminal that asked him to be saved, right? Jesus didn't tell him he had to wait 5 to 7 years. What he told him was, this day you enter paradise. You know, and I use that illustration because at the end of the day, when you pay your last mortgage payment or your last car note, you don't expect to get any further bills in the mail. Why should I?
Well, you seem to know that it's question time. Dan, you're planning to go? Yes. What questions?
Just,
And if you have to leave, we understand. Why don't we go back there to,
what we're gonna do, just so I can take just a second, you'll be calling on people, but I'm coming to you with the wireless mic because we want everyone in the room and the panelists to hear your questions. So please let me come to you.
let's see the questions over here again. All right, folks who have their hands up now, Dan, we'll go to you first. Sorry, I'll just work my way through.
Desmond, I just want to encourage everybody to go to the Florida channel and watch a parole board hearing. You couldn't see something that is in a sense more astonishing than to watch the clemency board do a hearing. So go to the Florida channel, type in the search, look for TV, type in the search clemency board hearings, look at the latest one. You go about halfway through and you'll see the rights restoration cases and look at what's going on. It is eye-opening.
Dan, we have a woman in a blue sweater in front of you.
For Dr. Snipes, 2 questions. Would you address the DMV on when you renew your license? I understand that if you don't check off your party affiliation, you're considered no party affiliation now, but that's a bit of a hiccup too. You didn't answer the jail question, not the felony question. Those in jail who have no conviction yet, how do they vote?
In this past election, we did go into the jail to take that opportunity to voters. I don't think a lot of them took advantage of it, but my staff went in and met with the designee from the sheriff's department so that we can set it up, but we'll go back again in the next couple of elections to get them registered, if they're not registered, out for opportunity to vote. So that was the jail. The DMV in the last, most recent election we had, we did come across some of the NPA voters, and we found a connection between their category of NPA and the last visit that they made to the DMV. These are individuals who said, I have voted Democrat all my life, I voted Republican all my life, I went to the DMV and got my license renewed, and now I am listed as NPA. So I think there's going to be an effort to see what's going on with that situation, to see if it can be corrected as quickly as possible. But we did encounter that situation.
Excuse me, I'm new to Florida. What's MPA?
NPA, no party affiliation.
NPA, thank you.
Now, we'll go back to the gentleman next to the lady in the yellow shirt.
I have a question. That large number of people that have felony convictions but aren't in prison, has there been a steady rise over time of the number of crimes considered felonies in this state? Have they been sort of manufacturing felonies?
Every year, a different felony is created. Some of the ones that I just highlight just to show, disturbing turtle nesting eggs, catching a lobster whose tail is too short. My favorite used to be when a gentleman here in Fort Lauderdale released 12 red balloons in the air on Valentine's Day instead of giving his wife a dozen roses. That's a third-degree felony in the state of Florida. Those individuals who voted unknowingly in elections, that's a third-degree felony. But my favorite now, and someone from the ACLU, I believe, ACLU member on the west coast of Florida did an op-ed, and he talked about trespassing on a pier. So, if you're taking your significant other on a pier, watch out for those signs, because if you trespass on a pier in the state of Florida, that is a third-degree felony. So it grows every year.
Mr. Nicole.
Hi, thanks. This is primarily for Professor Rohr. This is purely a hypothetical, but going to the other extreme, I'm kind of intrigued by those countries, particularly Argentina and Australia, where voting is mandatory. So that kind of wipes out everything we're talking about today. And I think they enforce it through tax breaks, so you don't get your full refund if you haven't voted. So they have extremely high voter turnouts in those countries. What stands in the way of passing something like that in the United States? Would it be constitutional for Congress to do it, and could states do it state by state?
Well, that's an intriguing question. I hesitate to bog the assemblage down while I think about it. As you look to Congress doing it, what could possibly be the basis of federal authority to do that? I don't think we can squeeze it in under regulating interstate commerce, and I also don't think we can squeeze it in under power to enforce the 14th or 15th Amendments. You're reminding me, I'm not going to drag this out. Remember some of the debate about the challenge to Obamacare, because they were concerned about the individual mandate? I think even Justice Scalia was the one maybe who said people can force to eat broccoli. This might be right up there. I'm not sure that Congress would have the power to require this should they want to. At the state level, there's no constitutional impediment to state legislatures enacting laws, needing constitutional authority to enact the laws. But would it possibly be regarded as some kind of due process violation to convict people for simply not voting? Not sure. Thanks for singling me out. Gentleman back there.
Hi, I've been working with voter registration. I've been doing voter registration for several years as a volunteer, and one of the, there are two questions that keep coming up, and it was kind of addressed today, but not as well as I would like. Party affiliation And what is the difference between an open and closed primary, and why does Florida have a closed primary system? Historically and philosophically, why, and how can that be changed?
Before you asked about the open and closed primary, was there an earlier question at the beginning there?
The first was the party affiliation. Why is that in there? Isn't that kind of a violation of privacy?
No, the party affiliation is simply you choose to be affiliated with the party. Keep in mind, primaries are not elections. We run them as elections, at least in this state, but they are not truly elections. They are simply an effort to choose who's going to run for election.
By private organizations.
By private
Parties
organizations.
being private
Now, that
organizations.
stated since U.S. versus Classic in 1942, where the primary elections were the real choices being made. And back in the day, the Democrat always won. In many states, the Republican always wins. Those primaries carry weight and that do fall under the various federal laws about running an election. The key is, it is your choice to affiliate with a party. And as for open and closed primaries, that is a choice of the state party, whether they want it just members of their party, or they want to open it to anyone who cares to have a say in their party. One is more democratic, small d democratic, to have an open primary. But if you think of parties as essentially private organizations that put forth slates of candidates to run for office, closed primaries actually make more sense. To simply limit to those who are willing to say, I'm a member. I could not vote in today's election for the board because I am not a member of the ACLU. This is a closed election. If it was an open election, I could have participated.
So when you have some concern about saboteurs, if you will, coming in, you know, perhaps you're a Republican and you get to vote the Democratic primary and you vote for the least plausible candidate because you're trying to weaken the opposition.
Yes, but why, there's a party affiliation, isn't it? It's private, why is that on a public state document? I don't understand it.
So you're asking not only about selecting the party affiliation, but having it be public record.
Right, why is that, I don't understand it, since it's a private organization.
Historically, your party affiliation was in fact not a private choice, but a public statement of membership. I can understand that you can make an argument that that affiliation should be deemed private, but that's not the way historically it was done or the way the law treated it.
Yeah, but I think it's a good question.
I want to say it's a trickier issue than you might think because, first of all, as to declaring what party you are, I mean, you show up and form Dr. Snipes has to decide, and you show up in a primary, or Dr. Snipes has to decide which primary ballot to give you. She needs to know what primary ballot you're entitled to. But look, there's an argument on both sides. What you heard before is the fact that what we're dealing with are private associations, and they have the right to set their own rules as to, you know, it's a private club, essentially, each of the political parties. They're deciding who it is that they want to be their nominees. Do they want to have outsiders in to help select their nominees? I think they'd be greatly resistant to that. But what I wanted to add to the conversation was something very important. In 1998, the Florida Constitution was amended to address this issue because there are large parts of the state of Florida that are homogeneous with regards to political parties. In Southwest Florida, I mean, no Democrat runs for a countywide seat or state representative or anything like that. In parts here, it's hard to find a Republican in this one. And the Constitution was amended whereby if the primary, if the candidate in the general election is going to be selected in the primary because the other party has put up no other candidate, then the party primary becomes an open election. Now, the problem with that is that some people have figured out a way around that by just putting a name on the ballot as a write-in, and a write-in closes the primary. But if they don't do that, if only one party is fielding candidates in a primary, that party primary, although a closed
just had that experience last year with District 2 for the county commission seat, where there were several candidates that were all Democratic. And in order to close the primary, a writing candidate came in to qualify 5 minutes to 12 on the last day of qualifying. That person was a writing candidate, and according to Florida statutes, a writing candidate must live in the district at the time of qualifying. However, a person who's not a writing candidate did not have the same requirement. That went up to the Florida Supreme Court, who ruled that it was unconstitutional to have 2 sets of criteria. However, when you get on the kind of the moral side of the issue, it is pretty much commonly known that a writing candidate has a purpose, not necessarily to win, but to close the primary. And so that's what happened, and as soon as that the writing candidate closed the primary, that was all done, then the candidate withdrew. So that's our system.
And we got a fellow in the back row over there, he's standing up now.
Thanks. This is a question from my colleague, Mark Rohr, Professor Rohr. He's in Canova, professor at the law school. So you had said that you didn't think Congress would have power to, in essence, have a national election law. I'm just wondering if there's any way to bootstrap it, such as by the way Congress has mandated seatbelts by saying to states you don't get interstate highway funding if you don't have a seatbelt restraint law. Anyway?
Yeah, good thought there. When Congress lacks the power to regulate directly, because there's no basis in the Constitution supporting the particular regulation, you were quite right in pointing out that pursuant to the so-called spending power, Congress can allocate funds to states or localities and put conditions, strings if you will, attached to the receipt of the money. And if the money is willingly accepted with clear knowledge that there are strings attached, this is in fact, as you know, a way in which Congress accomplishes a lot that it couldn't accomplish through direct regulation. So, is there some rationally related way in which Congress might allocate money to the states with regard to the election process that could allow what you suggest? I'm done with this topic.
To Howard, maybe you should hire this guy. And to Dr. Snipes, in the event that a voter's ballot arrives late into post office delivery and so on, is there a way, perhaps typing one's voter ID into the website, that the voter can determine whether or not the vote was actually counted?
Yes, I think we have a free access tool on our website, and the voter can go and check their status.
Who else we got?
This is for Dr. Snipes. What is your opinion of automatic registration?
About
What is my opinion of
Automatic registration.
online voter registration? You mean something? Yes. It's a law in Florida now, and it's going to be implemented in 2017. So it's here. Automatic registration? Oh, okay. You mean if a person does what? Turning the citizen? I don't know. We've always seen voting as an option. I don't know if I would support automatic voter registration or not, because it seems to me it's just pushing a person into a situation that they may not want to be in. And we have people now who are on the roads. We have, I think what we have to look at sometimes is that registration is not the only part of a voting process. It's registration and it's voting. We have 1 million voters on the roads now, and we usually see about 35–40% of them registered. So to push a person into automatic registration without any kind of consequence on the other end, you know, like my sister is from Peru, and she tells me that it is mandatory that everybody in Peru votes, and if not, there's a penalty. So to push everybody into automatic registration, if they don't, then what? So,
Can I see how many hands remain? I'm not sure we can keep going too long. How about the gentleman down front here?
I don't know if Desmond has mentioned it, but he also has spearheaded this petition drive run across Florida for the restoration of rights for felons who have completed their sentence. If you've got one of these, they're all over the place, please fill it out and make sure one of the board members gets it. My question was for Professor Zeldin. If we can, if it makes sense to assume that a voter ID in essence is a poll tax, and at the same time, we usually are looking to our government, whether local, state, or federal, to ensure a fraudless election, a valid election. What's the solution to ensuring that somebody can't vote 10 times a day on election day?
Well, there are multiple forms of ID that do not cost extra money that can be applied. It used to be that you had a voter card plus any picture ID that showed that you were you, with a signature on it was usually enough. They would have matched signature to the signature on file, and there was no hassles, no problems. The problem is that this is a sledgehammer to fix a problem that isn't even that. In-person impersonation, voter fraud simply doesn't happen in very large numbers at all. I mean, minuscule. And often when we do see it, we find that the problem is more error than intent. The one area where we do know that actual voter fraud does occur is in absentee balloting. Back in '97, the judge threw out a mayoral election in Miami because there was enough voter fraud through absentee balloting. And voter ID does absolutely nothing, zero, to affect that. So the one area where we could actually have a problem that probably deserves some better solution, we have absolutely done nothing about. And the area which there is no problem, we're hammering it with a sledgehammer.
Excuse me, Mark, could you stand up again? Could you get that stuff that's underneath your seat, please? Because I need you all to know that you're witnessing the greatest ambassador for ACLU Florida, right in Mark Eckert. And this is not like a first, this is something that he is, those stats are something that he's been doing continuously for quite a number of months. And so I just wanted to really recognize his efforts on it.
I'll tell you what, I'm not comfortable with the exercise of power here. Alex, the president of the chapter, do you want us to keep going with questions or to try to wrap it up?
Well, I got still a couple more minutes of questions.
I want to add one more thing to the response on voter fraud. I forgot who's was, but I want to say two things. First of all, number one, the fact that we are talking about voter fraud is a tribute to the success of right-wing propaganda, because it is a bunch of baloney and does not exist in terms of election day in-person voter fraud. As we said eloquently before, there is a voter fraud problem in America, and it's in the absentee ballot system. If you're interested in this, I would also suggest you might want to go to online, maybe YouTube or Google, the Stephen Colbert program, in which a couple of years ago, I made the claim that there were more shark attacks in Florida than there were cases of voter fraud, which was then put in fact and found to be true.
Those two gentlemen back there, Barry. There's Barry.
Real quick, Professor Zeldin, what is the future of online voting? I know Utah just did something. How did that experiment go? That could solve a lot.
I'm on something called the election law listserv. It's made up of law professors who teach election law, political scientists, and lawyers who litigate in the area. And there was a lively debate about the future of online voting. And what it really came down to is if we think we have problems with fraud and absentee voters, the potential with online voting is even greater. So it's something that people are working on, and there are technical problems that they can look at, it would be great. But at the current time, it's, for one thing, in Utah, they had a lot of problems with people who were dropped from the system, who entered in their number and wasn't accepted. I mean, the technicalities of it were awkward, difficult, and efficient. If they can be, these problems can be fixed, it's probably a good long-term solution, but we're just not there yet. Thank you.
Gentleman in the yellow shirt.
With respect to the voting restoration.
Very close.
With respect to the voting registration amendment of felons who remain felons for rights. First, let me commend Dr. Snipes on her uniform. She puts herself in the other person's shoes. She's wearing a prison uniform.
Thanks for noticing.
Aside that observation, 10 years ago I wanted to vote and I thought on your registration form it says guardians excluded. If you have mental, judged to be an alleged incapacitated person, you don't get a right to vote. Does that exist anymore? If you can be led to a voting booth, some of us have the right sense to know what's up, even though they're put in such a position, as I'm discussing with Howard Simon and the president of the ACLU in New York.
We understand the question.
Basically, it's still the.
That's a question for me. If you have been adjudicated as mentally incompetent, you have the right to vote. No, that's a right like the not having restored your rights as a convicted felon. Then that mentally adjudicated, mentally incompetent, and you lost your rights, then a person would not be able to vote according to the current law.
The gentleman over here.
My question is for Desmond, but let me preface my question with a statement that I despise Governor Scott. And I think this state is a typical example of hypocrisy for a guy that's the CEO of a company involved in $300 million worth of Medicare fraud. He's in the governor's mansion, and you're sitting here trying to get into the Florida bar, and you can't. So my question is, does the governor have the power, like the President of the United States, to give you clemency and absolve you specifically because of your attainments and your proof that you are a good person and a good citizen and you've worked hard so that you don't have to wait for 5 to 7 years? Can the governor, negate these requirements?
You can't do it by itself. And so, whether it's restoration of rights or whether it's a pardon, he would have to be one of 3 cabinet members that would vote for it. And so you can have the other 3 cabinet members say yes, but if the governor does not, then it's nothing is going to move. You have to be one of 3.
Have you tried that?
I've applied before. My application was kicked back because they claim that enough time has not elapsed, and that I think that goes apart to a couple things. Number one was that the process that they put in place, while before it was just a simple application that you had to fill out. Now you're basically going through the process as if you're asking for a pardon, and so you're having to get the court documentation from every county that you were convicted in, and it's just a process that a lot of people really can't afford or don't have the time to really go through, and so they made it a lot harder. And so it can be very discouraging, but when I looked at it, I'm like, you know what? I could apply now and wait for 10 years, or just join other people and get this fight and let's change the Constitution in a couple of years. So that's what we did. And on a side note, I used to say a couple of years ago that Rick Scott was the best thing that ever happened to Florida. And the reason why I said that, because I thought that he pissed off so many different groups that it would increase the level of civic participation to get him out of there. And that didn't work, and so I'm thinking Trump might be the same thing.
We have two more questions, we're taking them.
Two more, and that's it. Can you say that?
Hello, my name is Joe Stanicki. I worked a couple of weeks ago the primary election up in Pompano. And yeah, first of all, I want to congratulate Dr. Snipes for making voting more easy, even to the extent of no longer requiring postage on absentee ballot envelopes. But I mean, that eliminating idea that requiring postage would be a form of poll tax. And I just want to say that I'm old enough to remember when people back in the 60s were actually murdered just for leading voter registration drives in the South. I wonder how many people here recognize the names as Schwerner, Goodman, and Cheney. And I just, it really enrages and incenses me to see this crap going on. And if I had my way, I'd like to have these. I know reading the ACLU and our putting people behind bars here, but these creeps and plain words that try to make it harder to vote, I'd like to see them suffer the same penalties as you would for crimes like embezzlement or perjury. It just takes me off. And, not really, but all right. Keep up the good work.
One more question.
One more. Thank you, Mr. Mercer, to end this meeting, and that's when you get something interesting to think about. One of the major problems with elections in this country, and particularly in Florida, is called gerrymandering. Okay? It was important enough for the Florida Supreme Court to make all kinds of changes, to have all kinds of litigations, to have all kinds of problems. Okay? What is the ACLU, going to do considering getting independent people, to draw up districts? The political parties have way too much power, and we've got to get power back into the people's hands. Is there anything that the ACLU can do to see that gerrymandering is done on an independent basis? Thank you.
Is there anything that we're going to do to see that gerrymandering will be done on an independent basis? So to make gerrymandering more effective or more efficient? Is that what you're to improve gerrymandering? Well, what we did was write amendments 5 and 6 that the voters approved overwhelmingly in 2010, and then had to go to court about 4 times to defend them when they were challenged by members of Congress, and then they were upheld by the Florida Supreme Court. And so that the House, not the House, but the Senate and congressional districts have been redrawn. But I want to say there is a real serious point in your question. And the real serious point is that even though we did all that, it's still going to go on. And it's still going to go on because drawing of district lines are left in the hands of the legislature. All we were able to do is impose constitutional standards. What I would prefer is, I think what you're alluding to, we got to take that out of the hands of the legislature to begin with and create an independent redistricting commission. We tried that several years before Fair Districts 4 and 5. It was not done competently, frankly, by the league. It was struck down by the Supreme Court. But that is going to be the ultimate solution. Redistricting, but still in the hands of those who benefit, whose jobs depend on how the lines are drawn, is always going to involve some degree of gerrymandering.
It's criminal. What they did was criminal. But you have it in other states. California has it. Okay? So, it's already there. All we've got to do is maybe put it on a ballot. Put it on a ballot. We must have independent drawing of districts.
The problem
problem is getting it on the ballot, getting it through the ballot. I'm, one of these days, I wanna write the history of gerrymandering, drawing materials, and unfortunately, the conclusion I've come as I've been studying gerrymandering is you can't avoid gerrymandering. You simply have to pick which, no, they have gerrymandering there too. You simply have to pick what sort of gerrymandering you want. Because whenever you link voting to geography, somebody's gonna lose out.
And with that said, thank you for your patience, ladies and gentlemen. If you made it this long, I think that's a big prize for you.
Yes. Please give our panelists a round of applause. Everybody, our next board meeting is April 18th at Denny's, Oakland Park, Caroline, 6:30 p.m. Presentation for me on Simmons, Rice, Michael, Broward, Board members, please come over here.
Board members, please, we have a meeting. Oh, right.